Now, the first thing you ought to be aware of is that there are no awesome definitions of child abuse and neglect. There are lots of different ones, and there are some very good working ones. And if you look at Title IX, which we'll do in a moment here, which contains the definitions of abuse and neglect for child protection in New Jersey, there are dozens of them, and sometimes they seem to be in conflict. Sometimes they seem to be anachronistic. That is, they don't even make any sense anymore. They're from another era. So, pinning down exactly what child abuse and neglect is challenging. Nevertheless, there are some workable definitions in the research. Physical abuse, for example, has been defined as physical injury to a child, including, why would they put this in here? Deliberate poisoning. Geez, I didn't think that applied. Physical injury to a child, including deliberate poisoning, where there is a definite knowledge or reasonable suspicion that the injury was inflicted or knowingly not prevented. It has also been defined as violence and other non-accidental, prescribed means prohibited, prescribed human actions that inflict pain on a child and are capable of causing injury or permanent impairment to developing or functioning. So what's interesting about that second definition is, and what's common to nearly all definitions of physical maltreatment, is non-accidental. Throughout the country, if you look at child protection laws, you'll see the word non-accidental. Because we want to avoid intervening, getting involved in situations that are pure accident. However, as we'll see moving forward, child protection and the criminal justice system are two different things. We investigate very similar things. Often it's the same factual scenario, but the end game, the purpose, is significantly different. Thus, the law surrounding how to investigate and how to respond can be very different. Okay? But even saying non-accidental, right? Even in the context of child protection, to say, well, it's violence, it's a non-accidental injury. Nearly every, if not every state has that term in there in some way, shape, or form, non-accidental injury. But accidents can happen as the result of unjustifiable risk, right? If you picnic on the shoulder of Route 80 with your 3-year-old toddler, there was an accident. The baby got into the highway. I didn't mean it. So these things are kind of a tension sometimes between figuring out whether it's accidental or neglectful, right? Accident and neglect. Very difficult sometimes. Physical abuse can be effectuated through a variety of mechanisms. Beatings with hands, objects, shaking, inflicted submersion, batterings in schools, daycare, or other institutional settings, Munchausen syndrome by proxy. You don't get a lot of Munchausen cases, but people like talking about it because it's got a funky name and it's a weird psychological affliction. Culturally prescribed rituals, culturally different child-rearing practices, religion-related practices. I've had a fair share of those, and I know child protection has had those as well. And you guys in child protection have certainly seen them more than I have in criminal justice. That is, unusual rituals and child-rearing and religious-related stuff. That's dangerous. That's what we're going to talk about a little bit, about the cultural defense or the cultural explanation. And simply because it's maybe culturally accepted in some other place doesn't make it any less risky, depending on what it is. The consequences of child physical abuse can be severe. Of course, there's the immediate injury, but it's the psychological, it's the emotional impact that endures. That's what's so tragic about physical abuse of children and over-disciplining children and abusing them throughout their development. This is a time when kids are supposed to grow. They're supposed to develop, and they're supposed to learn by example. And when the caregivers batter them and emotionally and psychologically abuse them, their developmental pattern is going to be skewed. And some kids, unfortunately, are going to grow up and have life's problems, including running away, prostitution, suicide, disruptions in social relationships, eating disorders, depression, post-traumatic stress, and substance abuse. The pain lasts, and that pain manifests itself in a number of different ways. And the growing child and later adult will do things to escape the pain or the memories that are self-injurious. Prostitution, cutting, suicide. Before we look at sexual abuse and definitions, let's take a look at Title IX in New Jersey. Now that we look generally at this stuff, I want to focus a little bit more on how this matters in the law. Remember that second, what do we call those things? Course objectives. That second course objective talked about how statutory definitions and how we interpret words and how we interpret legal language impacts process, jurisdiction, outcomes, and all that kind of stuff. You know, what do we mean by that? Well, we have to think about the fact that the behavior of people and our interventions, whether it be through child protection or whether it be through the criminal justice system, the behavior of people is governed by large collections of words, right? Title IX is just a section of the New Jersey statutes that describes the DCPP jurisdiction and is essentially a blueprint for child protection in New Jersey. Title IX is just a book of laws that govern DIFUS. And I'll say DIFUS periodically because it's hard to shake the word, and I'll say DCPP. Division of Child Protection and Permanency.
Took the family out of it, which kills me.
People still don't even know who you are when you call and you identify yourself. They're like, I'm from where? From who? And that's yeah, you got to just say that. It's like, oh.
The judges screw it up. The workers screw it up.
Yeah, I'm not surprised. It'd take almost a generation for people to get comfortable with it.
Then they'll change it again.
Yeah, right?
Because that solves all the problems. Just change the name.
Well, Title IX is the blueprint for the Division of Child Protection and Permanency, or DIFUS. So, Title IIc is the criminal code in New Jersey. So Title IX is child protection's bunch of laws, all laws that govern DIFUS. And Title II, C like Charlie, is the criminal law. All of the criminal laws that govern people's behavior. Title IX, Title IIc. 2, C like Charlie. Now, there are other statutes that govern both the criminal law and DIFUS, but these are the two most relevant ones. Title 30 governs DIFUS, and there are other statutes that govern DIFUS. There are other statutes that govern the criminal law. But for our purposes, you've got Title IX, you've got Title IIc. So let's see what Title IX says in New Jersey about abuse and neglect. We saw some general definitions. And it is challenging because words are inherently ambiguous. Right? Words are capable of multiple meanings. That's what ambiguous means. Words and sentences are capable of multiple interpretations. One of the biggest discussions, one of the biggest national discussions right now is gun control, right? And I'm going to show you the Second Amendment of the United States Constitution. Here it is. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, gun control advocates argue, some of them, that sentence means, it's one sentence, 27 words, that when we drafted the amendments to the Constitution, and the Constitution is a limit on governmental authority, freedom of the press, freedom of religion, these are limits on the ability of the government to tell us what to do. Well, this particular limitation in the Second Amendment, gun control advocates would argue, this says that we're going to submit to the jurisdiction of the federal government, but we have a right to continue to have state militias, like the National Guard. We continue to have the right. You can't take that away from us. We want to continue to have a well-regulated militia. And that the right of the people in that militia to have weapons to defend themselves shall not be infringed.
So wait. What they're saying is that they're the militia? Is that what they're saying?
No, I'm talking about gun control advocates.
The advocates.
Gun control. If you believe that there's too many guns and there ought to be gun control, yeah, one way to interpret this is that the Second Amendment doesn't guarantee you and me to have a 16-round clip, whatever, automatic, semi-automatic weapon. Because the pro-gun advocates would say, wait a minute, and this interpretation has prevailed. Justice Warren called it the most tortured interpretation in the history or something like that. But those who are proponents of possessing weapons, the persons who want to carry arms, say this is a right for any person to carry a weapon, not just a militia. That this Second Amendment language says that every person in America has got the right to have weapons. The right of the people to keep and bear arms shall not be infringed. Okay? They see that as an independent clause, not a dependent clause. There's two parts to this, say the gun advocates. We got a right to keep a militia, and everybody else got a right to keep a gun. Because we want to make sure that we are not subject to tyranny again, like we were in England. Others argue that that is a sentence that means we have the right to keep militias, and the right of the militia to keep and bear arms shall not be infringed. That second clause is about the militia having the ability to keep guns. In any event, it doesn't really matter. We're never going to solve that here, and I don't even want to talk about that. The point is, you got 27 words here, and hundreds of years later, we're still trying to figure it out.
It's still ambiguous.
And words are ambiguous. Sentences are ambiguous. Language is ambiguous. And that's what keeps lawyers in business. If language was pristine and crystal clear, you wouldn't need a lawyer. You'd get the book, you'd look it up, and you'd know what to do. So my 11-year-old said to me the other day, he goes, why don't you just get the book? Look it up. I go, well, it's not like the definition of armadillo, Daniel. This is a legal issue. You know? What do you mean? You can't look it up? Well, you can't. You can't. You can get guidance, and sometimes things are black and white. Sometimes. But there's always a situation that doesn't quite fit the language. That's outside the language, or wasn't anticipated. Abused or neglected child means a child less than 18 whose parent or guardian, as herein defined, creates or allows to be created a substantial or ongoing risk of physical injury to such child by other than accidental means, Remember I talked about non-accidental before in the general definition? By other than accidental means, which would be likely to cause death or serious or protracted disfigurement or protracted loss or impairment of the function of any bodily organ. Semicolon, ... There's a lot of these here, but you could spend a month trying to figure this one out. Okay. First of all, there are words of degree here, right? Substantial. What's substantial? What's ongoing mean? I mean, we have to take our fact patterns and apply it here, and that's why we're lawyers. Judge, this was substantial. It's substantial. You brought the child on Route 80. You're having a picnic on the shoulder on Route 80. That's a substantial risk. It's a substantial risk of physical injury. The child might wander onto Route 80. And what happens when you wander on Route 80 and you're not paying attention? You get hit by a car. If you get hit by a car, okay, that could cause death or serious or protracted disfigurement. You may survive, but you may lose a limb, okay? You may be disfigured for a long time. Protracted means for a while, okay? For a long time. You may lose a bodily organ. So my little silly hypothetical, you would think it fits. There'll be some defense lawyer out there who will argue, well, it's not protracted, it's not serious. It was 4 a.m. Christmas Day, nobody's on the highways that day. The injury was less. The risk of injury was less. It wasn't substantial at that moment. Route 80 was closed in that section. But what about an emergency vehicle barreling down Route 80? Let's take a look at this kind of stuff in action by looking at the case of State versus Galloway. And you're going to hear about this case over and over again for the next week or so. I think your first discussion board is about Galloway. And I even have a audio clip posted because people are troubled by this decision. And it's about the interpretation of words, just like we looked at the Second Amendment a moment ago, just like we looked at Title IX a moment ago. We're now going to look at a criminal statute called Endangering the Welfare of Children. And it says, any person having a legal duty for the care of a child, or who has assumed responsibility for the care of a child, who engages in sexual conduct which would impair or debauch the morals of the child, or causes the child harm that would make the child abused or neglected, as defined in Title IX this, Title IX that, and Title IX some other Title IX, is guilty of a crime of the second degree. Any other person who engages in conduct or causes harm as described in this subsection to a child under 16 is guilty of a crime of the third degree. Well, let's just get this second degree, third degree business out of the way. Because this statute has two different targets. It has people who have a duty to care or assume a duty to care, and everybody else. People who have a duty to care or assume a duty to care are treated more harshly because they're guilty of a second degree crime. And a second degree crime is just a gradation of the penalty that happens if you're guilty. What I mean by that is, when you go to court after you commit a crime and either plead guilty or are sentenced, the judge has to put you in jail for a term of years or put you on probation. If you're going to go to jail, every crime, and we'll look at this more closely later when we look at criminal sentencing, every crime in New Jersey has a degree. 4th degree, 3rd degree, 2nd degree, and 1st degree. 4th degree is the least serious. When you get convicted of a 4th degree, the worst you're going to do is 18 months. Because the range of imprisonment options for the judge is 0 to 18 months. That's a 4th degree. 3rd degree is one bump up. There, the range of sentencing options, how long you're going to go to prison is 3 to 5 years. At least 3, maybe 4, perhaps 5. Not 18 months, 3 to 5. Second degree, one bump up. 5 to 10 years. 5 to 10 years. First degree, 10 to 20 years. 10 to 20 years. So now we're looking at this. We're deconstructing this endangering the welfare of a child statute. And we know that the target, the kind of person who might be guilty, can either be a second-degree offender or a third-degree offender. And a third-degree offender is going to go to jail for 3 to 5 years. A second-degree offender, 5 to 10 years. So if you're charged with this and you're a defendant, you're accused of endangering a child, first of all, you want to say, I didn't do it. Then you get 0 to 0. There's no sentence. You didn't do it. Go home. But if you did do it, you want to say, I ain't the kind of person who's a second-degree offender. I'm that other kind of person. So what's the kind of person that's a second-degree offender? Well, those are people who care for kids, basically. You have a legal duty to care for a child or have assumed responsibility for the care of a child. And it makes sense that the government's going to punish those who have a special relationship with a child, who children are subordinate to, right? You know, they're in control of the child, so they can exploit them. They can harm them more easily because the child has to answer to them. We break crimes down into 4th, 3rd, 2nd, and 1st based upon how blameworthy the person is, how morally offended we are as a society. If you think about the gradation of crimes, as I just described to you, if it's a 2nd degree and something else is a 4th degree, then that 2nd degree, most of us would say, is more serious. The person who did that is badder, more evil, a worse person than someone who committed the 4th degree crime. So we label these crimes and we dole out prison sentences based upon what we find to be more serious or less serious, more blameworthy. And if you look at it in the context of people who harm kids, the legislature or our lawmakers have determined that caregivers who batter and beat and burn and molest the children who they are caring for are more morally responsible than the average person who molests, batters, burns a child. Neither one are good people. But we've made a decision as a society in New Jersey that the caregiver who burns is a worse POS than the regular dude who's got nothing to do with the child who burns or batters. And there's legitimate logic to that, you would think, right? Because a kid is trapped. They're subordinate to the caregiver. They have no place to go. We talk about the child sexual abuse accommodation syndrome. We talk about abuse and neglect and the exploitation that caregivers can engage in. We always think about that kids, don't have a lot of options. They have to do what their teacher says. They have to do what their mom says or their dad says. So we treat it more severely. So you're going to be a second-degree offender. Now, we need to interpret this some more. The legal duty to care for a child, give me some examples of people who have legal duties to care for a child. I just spouted some out a moment ago. A parent. Who else might have a legal duty? A teacher. A teacher has a legal duty by the fact that they're a teacher and the students assigned to them. They have a legal obligation. It arises from their status as a teacher in a school. Maybe a babysitter?
Yeah. Anyone they specifically delegate to care for the child.
Someone that a caregiver delegates to care for a child, perhaps. What other ones by law, though? That's a delegation. You got teachers and parents. Is there anybody else who How about,
Staff at an institution.
what's that?
Staff at an institution.
Staff at an institution. Excellent. And you can run the gamut with institutions. How about a jail guard? Or someone who works at the detention center? Well, maybe.
Because of the mandated reporter status in New Jersey, doesn't that kind of blur this? Because if we have that mandated reporter of abuse, wouldn't that kind of make everyone legally responsible for caring for a child?
Well, simply because you're a man.
Well, you know what I mean? No, because it puts it at a whole new level, because everybody has the same responsibility to keep.
But that doesn't mean, no, you don't.
I know, but I think it kind of puts it at a different level.
We'll talk more about mandatory reporting later, but that's simply the obligation to report child abuse, and it applies to everyone. But it doesn't impose upon you the obligation to care for them. They're not subordinate to you, the child. It's not a relationship. We have no relationship with the child. You could be walking through Pathmark parking lot and see a woman busting her child in the head with her fist. You have to report that, but you don't have any nexus to the child. It's not. But I understand what you're saying, but it's a very weak link. It's a very weak link. There is a duty there, though.
Right.
And whenever there's a duty, there's a connection between the... We do owe that child a duty to report, though. You'll see when we read Galloway that
I could just see that being
that's not going to be a very persuasive argument to the Galloway court. But these are the issues. You know, what does it mean? What does it mean to have a legal duty? What about assuming responsibility? Some of you said delegate, babysitters, things like that. You would think that a babysitter is exactly the kind of person who has assumed responsibility for the care of a child. Well, whatever they look like, we know that they get treated as a second-degree offender. And every other person who's not a person who has a legal duty to care for a child or who has assumed responsibility for the care of a child, every other person is guilty of a third degree. Yes?
What's first degree?
It's not there. This is not a first-degree crime. But first degree is 10 to 20 years. There's no first-degree endangerer. In fact, when you read the Galloway case, it used to be third and fourth degree. The person with the duty would be a third-degree offender, and the most they could get back in the 1980s, was a 5-year sentence. And the person who had no relationship to the child, who did this stuff, would get 0 to 18 months. They've since elevated it, and now the non-supervisory person or caregiving person gets 3 to 5, and the supervising one gets 5 to 10.
When did that change?
I don't remember, the 90s or something. It certainly wasn't in effect in Galloway, the Galloway case. Now, the next issue is, I'll give you a hypothetical, you tell me. Suppose a school teacher beats a child with a yardstick in order to discipline them during school. And suppose the child is 17 years old. It's a high school junior. And to make a point in school, she whacks her repeatedly and significantly and bruises her with that yardstick. Now, first of all, we have to say, is there a legal duty? Probably. She's a school teacher, right? It's in the course of her employment in my little hypothetical. But what about the child being 17? Does this statute cover her? Well, you can be guilty of multiple things here. You can be guilty of assault and endangerment. It's an assault on a child, so they both could stick. No pun intended. But I made the child 17 and a high school junior. Would this law, read it, tell me if it would apply? It says something about kids having to be under 16. But it might still apply to the teacher. How does it still apply to the teacher? What? Why? So because of her role. Well, how does that statute? It says at the bottom, under the age of 16. Isn't that the Isn't that the age requirement in order to be guilty under this statute?
Well, no, you
That's what they're talking about everything.
could take it as an independent clause, that it's not, because it's a whole new phrase, you could read it as it's not dependent on the first section, but then to use it to your advantage if you're on the other side, you could blur it together.
And that's what you were all
Interpretation.
saying at the same time. Something like that. So it only applies to the third degree people. And the top one applies to everybody else. Well, how old is a child? Well, in Title IX, it's 18. You're not a child over 18 in New Jersey. So you would argue that the top part applies up to 18 and the bottom part applies up to 16. Is that what you would say? I would too. I agree with you.
Depends on what side you're working with.
Right,
That's going to have
right.
to be interpreted differently. and use it
Well,
to your
some
advantage.
judges have interpreted it the other way, and I've argued against it. And many lawyers come in and they read that quickly and they think it only applies. But I think if you look at the language there, I think it's pretty.
I think it's
Yeah, I think it's a pretty obvious independent clause there. I think we can win that argument, and it's never been successfully challenged. And the other argument is, as a lawyer, we haven't looked at it yet, but if you look at Chapter 14 of the Criminal Code, which has the sex crimes, the age of consent in New Jersey is 16. But between 16 and 18, if you are a supervisory kind of person, you can't have sex with a child between 16 and 18. It's a crime. So the legislature, in criminalizing caregivers who engage in sexual conduct with children between 16 and 18, because the legislature handled that sex crime section that way, you would argue that in order to be consistent, because among the kind of offenses here is sexual conduct. In order to be consistent, the endangering statute should also treat up to age 18 as actionable under this law. Because under the child sexual assault statutes, 16 is the age of consent. So any other person who does anything to a kid over 16 sexually that's not a caregiver isn't guilty of anything, just like this one. So any other person up to 16, but caregivers up to 18. If you look at Chapter 14, which we're going to do in a minute, the sex crime statute, sex with kids up to 16 is a crime for anyone. Beyond 16, only for caregivers, just like this. And that's another way you make arguments in a courtroom. You say, look, the legislature needs to be consistent. If the philosophy is that kids between 16 and 18 need special protection from their caregivers under Chapter 14, which is another section of the law books, why would they act differently here? I mean, it only makes sense that they'd want to be consistent in the logic of how they protect kids. So that's another. You have the language analysis, like you did, the independent-dependent clause, and then you also have the argument that the legislature is presumed to be consistent when they pass laws, and not inconsistent.
Does that apply to same gender, I'm talking about female, sexual contact minus the penetration? Does it apply?
We're going to look at that right now. The sexual assault statutes in New Jersey are gender neutral, so it doesn't matter. Before we do that, let me just wrap up the endangering. You'll see in Galloway that the legislature interpreted, the Supreme Court interpreted the first section quite differently than I think most of you would have. And they essentially said that a person who has assumed responsibility for the care of a child, that means something more than occasional or once in a while kinds of relationships. It requires something that's consistent, ongoing, regular, routine. So imagine if My son is 11 years old. His little 11-year-old's friend's father said, Mikey's having a birthday party. Can Daniel have a sleepover? And I said, cool, I want to go out. That night, this will be great. Saturday night, go on a date, he can have a sleepover, all is good. Paul C. in my community comes, he picks Daniel up, he takes him to his house. Now, if some bad act happened, well, not with my family, let's get it out of my family, but let's say the man who had the baby on a sleepover molests the kid. Guess what? Under Galloway, he didn't assume responsibility for the care of the child. Now, on a general level, I feel he did. You would feel he did. If I came by your house and you were my neighbor, I said, listen, we're all going down to Point Pleasant 9 o'clock in the morning tomorrow to go to the beach and go on the rides. If he's still there, sadly. Your daughter Gabriella and Danielle, they want to call, yeah, go ahead, Joe, take Gabriella and Danielle. Come on, I'll pick them up at 9 sharp. We're going to get on the highway before the traffic. My neighbor, who allowed me to take her 2 children, she certainly thinks I'm assuming responsibility. If they get stung by a jellyfish, I better do something about it. They are thinking that that's what I'm going to do. And I have, not in a legal sense, though. The Supreme Court said, you know what? If you bust that first sentence open, see the or is, we call that in language the disjunctive, right? The conjunctive is and, remember from English 101? The disjunctive is or. So we bust those 2 up. The court says both of them are second-degree offenders. The person who has a legal duty and the person who assumed a duty. So they are treated equivalently under the law. They're treated the same under the law. Same under the law, each one. Okay? So the level of supervision, the level of relationship needs to be equivalent. Because the outcome is real serious here. You're looking at 5 to 10 rather than 3 to 5. And in the Galloway case, it was probation versus 5 years in jail, because it was 3rd and 4th. They said, look, the legislature wants to treat people who have a legal duty, because they're more evil, they're more blameworthy. They should be punished more severely. Teachers, parents, institutional people, jail guards, somebody who's maybe kids in a hospital for the emotionally disturbed or in a hospital under the care of somebody. These are serious, serious obligations that the law imposes on people. And the guy who watches the kid while you go get a pack of cigarettes or go pick up some stuff at the Pathmark, or the person who takes your kid for 3 or 4 hours up to the lake, you really can't argue that that is the equivalent in relationship between somebody who's a teacher or a jail guard. They're both doing similar things. They're both caring for kids that aren't their own. Or they could be their own, actually. They're both caring for kids. But the Supreme Court said they're not the functional equivalent. An occasional caregiving or an occasional babysitting doesn't give rise to the special kind of relationship that ought to be punished more severely. The people we want to punish more severely are people who have a legal duty. It's written in the law that they have to care for these kids. And they have a significant legal duty. So for the other kind of person who assumes, they need to assume something more significant than once in a blue moon stuff. Whether you agree with it or you don't, it's the law of New Jersey. And you'll see when you listen to my audio clip, a lot of people get upset because Galloway beat this. Galloway was the mother's boyfriend. And I forget, you'll read the case, and I don't remember if he lived there or he went back and forth, but it's a typical kind of paramour case we see a lot. And he was in the house a lot. But he didn't live there. You know, there was all kind of testimony. Well, he put his stuff there, he would go home. You know, when it's in his interest to not live there, guys are like, oh, I'm not really there. I really didn't like her. I was just hitting that. I was really into her, you know, this and that. But if it was in his interest, he'd go to jail for less time. If he lived there, oh, I loved her like I was there. Yeah, my toothbrush was there. I was going to put an addition on the house. I lived there. Well, it was important that he didn't live there and didn't have a significant relationship with the child's mother. So all this stuff came out. You'll see the opinion about where his suitcase was, his toothbrush, or all that kind of stuff. But more importantly, his relationship with the child was the thing that the court focused on. And they ruled that it has to be significant, it can't be occasional, it can't be once in a while, it needs to be continuous. Now, I'm teaching here on Monday nights. I'm all with you. I got an 11-year-old, I'm a single dad. If I drop Daniel off every Monday at Paulie C's house, where he had to sleep over Saturday, now he's on the hook for the second degree.
Because there's a relationship ongoing.
Well, it's an ongoing, continuous, blah, blah, blah.
Once in a while.
Not just once in a while. Now, Saturday, Daniel hasn't slept over this guy's house in a couple of years now. The boys are friends. When he was 7, he stayed there overnight once, but it's exactly what the court says isn't that relationship. It's once in a while. Has to sleep over once in a while. And not in the past 2 years. People get upset because Galloway was a murderer. Galloway shook the baby to death. It's a shaken baby case. And when you read that decision, most of my students over the years, I don't believe that's outrageous. Emotional. Galloway didn't beat anything. He got 30 years because he was convicted of murder. But on endangering, he won a little battle here. Instead of a second degree, he's a third degree guy. You'll take a closer look at that and you'll argue and talk about it in the discussion board. That's why the discussion board, I really gave you a push. So I know that discussion board is imminent Thursday, Sunday, but you know what I'm talking about now. You'll do fine and you'll chat a little bit more about this issue. Go ahead.
Is that still the standard? That it has to be a constant relationship? Or it's...
Yes, it has not changed. Galloway is the law of the state of New Jersey to this moment in time. And it comes up a lot in my practice. Now, we talked about sex crimes and how they are treated. Now, I'll give you a couple of quick examples about language, just from this statute here. I've been prosecuting sex crimes since 1992. I know this statute inside and out, upside down and sideways. I've had cases that involve nearly every one of these words. Okay? These are simply the definitions. Because if you look at the crime itself, let's go there first, it's probably better. Here's the crimes. An actor is guilty of aggravated sexual assault if he commits an act of sexual penetration with another person under any one of the following circumstances. Okay. We call these elements in the law, right? So what does a person have to do? You have to penetrate somebody. Okay, what does that mean? You think you know what it means, but you don't. Not under New Jersey law. With another person, oh, that's easy. Well, what about a corpse? Is that a person? I don't know. Victim is less than 13. Victim is at least 13, but less than 16. And actor is related by blood or affinity to the third degree, has supervisory disciplinary power over the victim, foster parent, guardian, or in loco parentis. Whoops. Or it was a robbery. We don't need to worry about that. We're going to worry about kids. An actor is guilty of sexual assault if he commits an act of sexual contact with a victim who's less than 13 years old and the actor is at least 4 years older than the victim. Well, there's another example. Excuse me. This is interesting. If the child is less than 13 and you fondle them, contact, not penetration now, contact, it's considered sexual assault in the second degree. The same fondling, for example, if a molester touches the butt of an 11-year-old for sexual purposes, it's a second-degree crime. It's considered sexual assault in New Jersey. Serious crime. Because we protect our youngest, our littlest ones. Another molester fondles the butt of a 17-year-old who's working the French fryer at Burger King. Fourth-degree offense. Simple sexual contact. Fourth-degree offense, probation. Kid's age is less than 13. Second-degree offense, we all know now, 5 to 10. So it matters. Age matters. Contact or penetration matters. Words matter. Words help or contribute to jurisdiction, outcomes. When I say outcomes in that course objective, how long you're going to go to jail, what court you're in, are you in family court or criminal court? So all these words matter. Okay? Now, let's take a look at...
I have a
Yes.
Is there a difference between aggravated and just regular?
Yeah, aggravated's first degree. They just gave it the label aggravated. Sexual assault is second degree. Aggravated is first degree. So the first degree is called aggravated. The second degree is called, doesn't say anything, sexual assault. Some might call it simple sexual assault, but that seems oxymoronic. You didn't want to put the word simple in front of sexual assault. Kind of makes it, oh, it's just a Saturday night thing, you know. So it's simple assault, second degree. I mean, not simple assault. Sexual assault, second degree. Aggravated sexual assault, first degree. It's just a label they gave it. Let's look at language now. We said penetration. Okay. Let's go see what penetration is defined as. Vaginal intercourse. Okay, that's the one we all think of, I think. The insertion of the male penis into the female vagina. Right? That's what vaginal intercourse means. Generally speaking, under common law. But now, under the modern formulation, it also includes cunnilingus. Cunnilingus is oral sex on a female. It doesn't matter who the person is doing it, okay? But you need a vagina to be involved in cunnilingus. But the person who puts their mouth there could be a man or a woman, it doesn't matter. So cunnilingus is the oral stimulation of the vulva or the vagina. Fellatio is oral stimulation of the penis. Anal intercourse, self-explanatory, insertion of the penis into the anus of another person. Or insertion of the hand, finger, or object into the anus or vagina, either by the actor or upon the actor's instruction. Now I'll give you two quick cases I handled that show you how language can make a big difference. Dr. Alan Lupinacci worked in West Paterson, New Jersey. And in the mid-1990s, I get a phone call from the chief, or my supervisor did, and they said, go see the chief. They got 3 ladies there that say the doctor touched them. The doctor, everybody knows, everybody loves. He treats a lot of the police officers' wives. He's a very successful and well-known and prominent general practitioner in our community. And we don't know what to do. So we went down, we took jurisdiction in the case immediately. We interviewed those 3 women. State medical board representatives met us there. 2 of the women knew one another, but not from town. They just knew each other from the waiting room. Because you worry about a doctor, maybe he's being falsely accused. Everybody thinks that way sometimes. But they knew each other from the waiting room, and the third person didn't know the other 2 at all. And each one of them told a very similar story. The doctor examined them. One went in for a sore throat. One went in for some other malady. He convinced them to have a gynecological examination and a pap smear, which the medical board told me after I arrested him is the right thing to do, and I'm going after a good man, and he's falsely accused and all that. And I was quoted in the newspapers as saying that Dr. Lupinacci convinced women to have unnecessary pelvic exams. So the president of the Passaic County Medical Association and some other medical advocate called and left messages, and they wrote letters saying there's no such thing as an unnecessary pelvic exam. And, well, I understand what they're saying, you know. Simply because a woman went in for a sore throat doesn't mean the doctor can't say, when was the last time you had a pelvic? No, they encourage doctors to go, well, 5 years ago, well, you better have one, right? So that's what these doctor advocates are saying. But when the purpose of the exam was to arouse them sexually so he can get aroused, that's an unnecessary pelvic exam, you see? He didn't do it for their medical health. He did it to sexually gratify himself. That's why it was unnecessary. But nevertheless, all of these women, the first 3, went in there and he found a rash. Once he gave them the fake pelvic exam, he found a red rash. And he said, well, we're going to put this cream on it. More often than not, it was bacitracin, which you could buy at CVS. Sometimes, one woman later said it was Curry Oh-So Soft. It was just hand cream. And he would apply the cream to the point of orgasm on some of these women. And some women orgasmed because at the end of the day, after we arrested him, there were 39 victims. Probably 139. 39 women came forward. I indicted them on 100 and something counts of sexual assault. Now here's the issue. These are adult women. Kids you don't really have this problem with because they don't really appreciate their anatomy, female children. Many of the women said, no, did he put his finger inside you? Well, not really. He just rubbed my clitoris with the cream. But he was doing it very roughly, and I thought it was, and I said, what are you doing? He said, no, I have to put it on. And a lot of the women had different reactions. And I know some women, when I was prosecuting this case, I would never, how could he do, I would have jumped off the table and popped them one, That's you. He knows who he's picking. And a lot of people, you're in a doctor's office. So it wasn't that clear that this guy was a criminal and a pervert. Even to really, some of these women were sharp, professional women. And they ranged from 17 to 68. In any event, the issue became whether the stimulation of the clitoris was sexual penetration. Because if you look at the statute, okay, the statute says insertion of the finger into the vagina. Well, any physician will tell you that the vagina, the clitoris is extravaginal. It's outside the vagina. The vagina is a very specific part of the body. And if it leads from the uterus to the cervix, and it's a canal, the vaginal canal, and the other parts of the anatomy, the female anatomy, the clitoris, the labia majora, the clitoral hood, all this anatomy is outside of the vagina. I don't think the legislature was thinking of these things when they were down here in Trenton, I mean. The legislature was thinking of any kind of intrusive behavior down there. But they picked a word. They picked the word vagina. And vagina means something. And my adversaries weren't going to let me have this one. They brought in a picture from Stedman's Medical Dictionary, nearly as big as that screen, of the female vagina. And back then we didn't have PowerPoint and all these, projectors you could buy for $100. This was, they had this perfect, he had Crummy Del Deo, he had Robinson St. John, he had all kinds of legal talent there. It was like 7 people sitting with him, I exaggerate. 3 people sitting with him, and him, and then me. We had this little dream team there, and they brought in a Stedman's Medical Dictionary. I remember Judge Marmo, he was working at his bench. They come out from the side, the judges, and they go there.
They don't look very good.
What is that? Del Russo. What's going on? Del Russo in the house? Oh, no. And quite clearly, with this giant blow-up. Fortunately, some of the women described penetration. They knew he put his finger inside and he did X, Y, and Z. So I conceded that point because I didn't want to make bad law, because I knew the children in my cases had a hard time describing what happened. And I knew that the theory, which has since really been virtually proven in child maltreatment and child sexual abuse, was that children are never really totally penetrated, that the molester rubs his penis or his finger on the labia and achieves arousal through friction, through rubbing. And that wouldn't be penetration. If I went to court and lost this on the Dr. Lupinacci case, I'd be throwing all the kids under the bus. Because in most cases, we would indict them for first degree or second degree. We'd indict for penetration. We would charge for penetration. But if the law became, based on this case going to the Supreme Court, that stimulation of the vulva, of the labia, the body parts outside the vagina is not penetration, it would have hurt the prosecution of children's cases. 10 years later, the court said, as they became more wise and as things changed in society and life, that that's enough. That vagina really didn't mean vagina, we meant vulva, we meant it includes all of that anatomy. But back then, we didn't know in the mid-90s, and I certainly didn't want to, I didn't want to make bad law that would hurt the kids. So we went that way. Plus, I had other counts in the indictment. I had other guys, other women that he sexually penetrated. You had something you wanted to ask?
Well, I was just thinking about, you were saying that these women went in for like a sore throat. I mean, I don't know, personally, I don't know that I would ever let my normal doctor give me a pap smear if he's not a
When you
gynecologist.
convinced them, when was the last time you had a pap smear?
I mean,
But you know what?
But
does that
not
mean-
like new age that everybody
This is also 20 for everything.
That's you.
Some people would be more comfortable with their regular.
No, general practitioners, a pap smear is not heavy lifting. It's not that hard to do.
Yeah.
It's not a lot. Now you may feel more comfortable with your gynecologist. Many women didn't and don't. Believe me, I didn't do a survey, but in preparing this trial, I talked to a lot of different women. And the medical boards are like, oh no, GP, absolutely. Did we teach them to do that? They're fully capable of doing that. Now, there are all kind of GPs. Some GPs won't want to get involved in that at all. And now, as Susie's suggesting here, we're moving more and more towards specialization. And what was in the mid-90s and 2013, maybe no one goes to their GP anymore. But it's not that, we ask our GPs to do lots of different things. Remember, he was a family doctor. A lot of these women knew and trusted him, and this wasn't a lot of medical analysis that's going on, to do this kind of thing. Don't they take a swabbing or something? I'm not quite, I forget what happened, but it wasn't that much, it wasn't that involved.
It's something he was trained to do and was capable of doing appropriately.
Yes, and without much specialization needed, though, to do a pap smear. Now, if he found some growth or something unusual.
He's not doing a hysterectomy or something.
Or he's not finding a growth or something abnormal, or I'll take care of that. No, I want to go to, you better go to a specialist. But in any event, whatever the reasons were, these women were legit. It happened. They said, okay. Some of them, like I said, they treated their kids. He was the guy who came out with the bag and would come and make house calls. He was the lovable, likable doctor. So in any event, so that's, you see how the language and the words can make a big difference. Now, I'll tell you about a different case. See the rest of this language here? Insertion of the finger by the actor or upon the actor's instructions. James Maxwell. This case went to the Supreme Court. James Maxwell's mother died. And he lived with his developmentally disabled brother, who was not really socially functional. He was in his 40s, and he inherited the house from his mom. And what he did was, he was sexually aroused by kids. He was a pervert and a molester. He would look in the local papers up in North Halden area in Passaic County, and look for kids who were in grade school whose names were in the paper. And you'd be surprised at how many people's names and phone numbers were still in the white pages in the mid-90s. So if it said, Danielle Pasillo, he'd go in the yellow pages, because he'd see Danielle Pasillo won the spelling bee, or she won a trophy in softball, in the 9-year-old league or the 10-year-old league. And he'd look up the name, and he figured some of these are latchkey kids. So he called them on the phone between 3:40 and 4:30, and he got a lot of them to answer the phone with no one home. And then he'd say, oh, I'm Dr. Maxwell. He had a different name, but his name was Maxwell. Yeah, what do you want? Well, your mommy told me that you had a problem with burn when you went pee-pee. No, I didn't say that. Well, your mom told me there may be something wrong with your pee-pee. In any event, he has a maybe 2 or 3 minute conversation. He got the children, the female children, to put their fingers into their vaginas, then smell it and tell them what it smelled like on the phone. Now, I charged him and indicted him and prosecuted him. My adversary said at best, the other lawyer, the lawyer for Maxwell, said at best, this was harassment. These are phony phone calls. Del Russo indicted him for sexual assault. Aggravated sexual assault in the first degree. Del Russo wants him to go to jail for 20 years. He never even met the kids. He wasn't even in the same room. They were calling it the virtual rape case. It was on the cover of the New York Times Sunday magazine. Not this case. It was a little blur, but it was in there. Colin Powell was on the cover, but it said the virtual rape case in a little 8-point font at the bottom.
It was there.
It was there. And if you opened it up, there was about 6 or 7 pages that talked about this case. And I argued, I just got my law book out, as Daniel would tell me to do. Joe, just get your law book. Got my law book out, and it says here, insertion of a finger into a vagina upon the actor's instruction. Looks like it fits to me. Works for me. And his argument was that there needs to be a temporal and a physical a physical relationship. They need to be together in some way. And I said, the law doesn't, require or say anything about they have to be in the same room. But how could you have this? How could you do this? And it was interesting and a little bit sexy because we were beginning to have the internet. And, people were beginning to chat. This was the early days of chat and virtual, people communicating. I don't think it's that interesting nowadays because people do all kinds of things that are a million miles apart. But back then, and he was decidedly low tech, right? He's using a phone, for Pete's say. Not here. But again, there was a lot of hearings and a lot of discussion about what these words mean and whether they apply or not. Okay? Intimate parts. I prosecuted Father Peter McBride, who was a Roman Catholic priest from Clifton. He fondled a girl in the confessional. And I was like, I went to Catholic school as a boy, K through 8, and I'm like, wait a minute. I went into confessional, there was a screen, it was like, it was very medieval, even a thing came up. You didn't know who was Father Russo or Monsignor Willis, you really couldn't tell. You kind of put your eyeball, it was a very pinhole screen. They told me nowadays, this is in the late 90s, nowadays you sit next to the guy if you want, or gal. Well, not in the Catholic Church, guy. You look at him, you sit right next to him on a bench. So she sat on a bench, he was fondling her, but he fondled her thigh. Not enough, I had to know what part of her thigh, right? Look at the statute. Intimate parts means the sexual organs, genital area, anal area. He didn't touch any of those parts. Inner thigh, groin, buttock, or breast of a person. So it became supremely important to find out where exactly on her thigh his hands were. Or it wasn't a crime.
Thigh begin in it?
I don't know. I don't know what an inner thigh is.
There's no
Yeah. Well, how do you,
there's no
you know what? You leave that to the lawyers. I say the inner thigh is 98% of the thigh. They say it's 5%, and we'll figure it out. Then you have this case called State in the Interest of MTS. And you want to really learn about how the law grapples with words and definitions. You look at this case. And we'll wrap up with this one. The law says, and this is this part that has to be interpreted in MTS. Regular old sexual assault, if you commit sexual penetration and the actor uses physical force or coercion. And that kind of seems like the standard definition of rape, which we don't call it rape anymore for a variety of reasons. We call it sexual assault. Physical force or coercion. The defense lawyers in Dr. Lupinacci that I described to you a little while ago, they argued that there was no force or coercion, and there wasn't. They argued that the women consented. We had multiple hearings on this issue. Now, I argued that consent is vitiated, or there's no consent if there's fraud, and he was a fraud. I argued that there wasn't consent. Consent was to a medical exam, not to sexual conduct. But they did not stop them from arguing it. And on a certain level, there was consent in the case, and certainly I couldn't point to extrinsic force. I couldn't point to a gun or a knife or a thread or anything. They said, go ahead, take the cream and rub it. They agreed. There was no force or coercion. But then came State in the Interest of MTS. MTS was two juveniles. It didn't involve a child and an adult where 4 years and age difference mattered. It involved a sleeping victim. And the male penetrated the female while she was sleeping. The defense lawyers came to court and said, hey man, we can read the law book. It says you need physical force or coercion. There was no physical force or coercion. And all the lawyers in the courtroom looked at the law and they said, you know what? It does say that. There was no physical force or coercion. And guess what? No other statute fit. This is the one that fit. And the defense lawyers probably said something like this. You know, Your Honor, what my client is accused of doing, which he didn't do, but what he's accused of doing is repugnant. It's an outrageous and intrusive act on some other human being. But it ain't a crime. And this may need to be fixed. The legislature should change this. Because he didn't do it, but somebody who would do that ought to be prosecuted. But you can't prosecute him. Because in America and in New Jersey, you can't prosecute someone today for something that isn't a crime. You can't prosecute someone today for a crime that's passed tomorrow. It's got to be a crime at the time it happens. Because it's about notice. You are theoretically on notice when you pick up the book of laws and crimes. You know, I can't be doing that. It's in the book. If it ain't in the book, how do you know what not to do? That's an oversimplification, but we're a notice state. It's got to be in the criminal code. There's no common law in New Jersey where there are certain crimes everybody knows about. So the lawyers for MTS, right, they said, hey man, it is a terrible thing, but you can't hold him responsible. They want to change it, but you're not going to change it by putting him in jail. He needs to go free. Messed up. No, the Supreme Court said something interesting. They said, well, let's take a look at that term, force or coercion. Let's take a look at sexual assault law in New Jersey. And it's a beautiful opinion. You have to read it. But I encourage you to read it. I know it's got a little bit of lawyer-like stuff in it. It may make it a little hard to read at times, but not much. They go back to the 1600s and the 1500s and look at sexual assault law. The Supreme Court examined sexual assault from the Middle Ages to 1994, when this case was decided. And ultimately they said, you know what? What we mean by force or coercion in New Jersey is when somebody has sexual contact or sexually penetrates someone without their free and affirmatively provided permission. That's what we mean by force or coercion. When somebody has contact with someone or penetrates them without their permission. And the defense lawyer said, what? What are you talking about, man? Permission? People need to get people's permission now and write it down? What are you talking about? And I remember the defense bar went crazy when this case was decided. And I remember they called me for a quote, a couple of newspapers, they called Miles Feinstein, Lou Esposito, other lawyers that practice criminal law in our community, and they were, this is outrageous. How do we know what's legal and what isn't legal? The Supreme Court had a tortured analysis of this phrase. It's rather simple. Force and coercion. What is this consent stuff? Well, think about it this way. Anytime you penetrate another human being's body without their permission, you're committing a forcible act. When you put your finger in the vagina or the anus of another human without their permission, you're sticking it in there by force, right? If that person's not consenting, the forcible act is the unconsented to penetration or the unconsented to touching or fondling. The court said to look at it any other way would be to require that there be some resistance. Because if you require that there be some actual force used by the perpetrator, the only way that you can really measure actual force, think about it if they interpret it and say, no, you have to have actual force. Lack of consent isn't enough. The person has to force or coerce them. And you're a prosecutor. Right? And you need to prove this in court. And the woman, mostly women that are sexual assault victims, the woman comes into court. Did he force you? Yeah, he held me down, he pushed me, he poked me, he slapped me. What would you look for to help show that she was forced? What would you want to know about her appearance? Yeah. It's hard to prove force without showing some injury or some resistance. And many years ago, before the MTS decision, when the sexual assault laws were passed, they got rid of the requirement that women, we'll talk in terms of women resist. You know, the old sexual assault law, women had to, never mind, not only had to be forced, you had to resist to your utmost. There was no such thing as the Supreme Court called it as a tactical surrender. And research has shown, and the Supreme Court talks about this, women who resist and fight back get injured more and sometimes killed. So we're not going to live in a state where you got to fight back and maybe get killed. So if a woman knows that if you fight back, you may get severely injured or killed, so they don't want to fight back, but if they don't fight back, they won't have their case prosecuted because they didn't cry. The Supreme Court looks at all these things and comes to the conclusion that I just said. And it's an elegant decision. It's really well written. Really well written. And interesting. But again, it really turns language on its head. The definition of force or coercion. And I'll tell you about other cases where this came up throughout the years that I prosecuted that illustrate what the MTS course was talking about. MTS court was talking about. Any questions about that?
Couldn't you use like the victim is one who in the afternoon should have physically helpless, mentally defective, or incapacitated because they're sleeping time? So I mean, couldn't it?
Yes, that would have been a good argument, and they may have even indicted for that as well, that they were physically helpless. It's a little bit of a stretch. It's not a neat fit, but it's close. In Dr. Lupinacci, I argued that the women were physically helpless.
They were also coerced indirectly because they trusted somebody.
Well, that's a little bit more of a stretch, but physically helpless. Remember, they went in there.
They were sick.
They went in for medical treatment, and they were in no position to interpret the validity of what he was doing. When you go to your doctor, you give yourself to him or her. Go ahead. He says, get out of thing, do this, stand over there, take off all your clothes. You're not in a position to challenge them. And they're in the worst position because they're laying on this thing with their feet in the air and their head back. So it was a decent argument. Anyway, I'll see you all next week.